Hello aspirants, here I am Pallavira and today we will talk about the chapter 3 of Indian Penal Code. Chapter 3, as we are aware, chapter 3 deals with the punishment. And if we want to study it easily, we could divide it in a three part. In first part, punishment and its kind and its procedure we could keep, and in second part we could keep rule for assessment of punishment, which is section 71 and 72, and in third part enhanced punishment for subsequent offenses, which is section 75. So today we will do the two parts, means second and third part, which is rule for assessment of punishment, which is section 71 and 72, and enhanced punishment for subsequent offense, which is section 75. So let's get started. If we go through the section 71, we will see that there is a limitation of punishment. What kind of limitation it deal with? The limitation of punishment of offenses if it made up of several offenses. Actually, this section governs the whole code and regulate the punishment in cases in which the greater offenses is made up of two or more minor offenses. So if we see the section 71, we could see that it is a lengthy and it consists of four parts. And para 1 says that where an offense is made up of parts, and each of which constitute an offense, the offender shall not be punished for more than one offense unless expressly provided. So if we see that if offender has decided to commit an offense and in pursuance of commission of that offense he had committed some minor offenses as well, and that offenses are also punishable under Indian Penal Code or any other law for the time being in force, we could charge with many more offenses. We could charge for that minor offenses along with that penultimate object, that penultimate offense, but we could not punish for each of offense unless expressly provided. We could punish with only one offenses. We could punish him with one punishment for one offense. We could charge him, as section 220 of CRPC says that if the offense is a part of same transaction, we could charge and try together. We could charge and try together, no doubt, but we could punish only with one kind of punishment, only one offense, not for all the offense unless expressly provided. When we go through the para 2 and 4, if we read it together, it means that where an offense falls within two or more separate definition of offense, the offender should not be punished with more severe punishment than the court which try him could award for any of such punishment, any of such offense. What does it mean? If when the offense falls within two or more separate definition of offense, the accused has been charged with those offenses and its trial goes on, the court which try him could award only for any of such offense. He could not award for all offenses, but he could award only that offenses which he has empowered, which he is empowered to punish. If we go through the section, if we go through the para 3 and if we read it, what it says that when several act of which one or more than one would by itself or themselves constitute an offense, or constitute when combined a different offense. When we combine those offenses, it constitute a different offenses. The offender should not be punished with a more severe punishment than the court which try him could award for any of such offenses. Here is the limitation, that it is a judicial limitation on the court, that if offender is charged with many offenses while conducting the trial of the trial of that offenses, magistrate could award him those sentences for which he is empowered. But what if when he could not, if he found accused guilty of those offenses, and he wants that accused should be awarded with those kind of sentences, but he was not empowered to do so, what he will do? He will follow the procedure of section 325 of criminal procedure code, in which procedure when magistrate cannot pass sentence sufficiently severe. Whenever a magistrate is of opinion, after hearing the evidence of prosecution and the accused is guilty, that he ought to receive a punishment different in kind or a more severe than that, which magistrate is empowered to inflict. If that magistrate is of second class and it is of opinion of that magistrate that accused ought to be required to execute a bond under section 106, under what section 106 of CRPC says? Section 106 of CRPC says for security, for execute a bond for keeping peace and security. He may record the opinion and submit his proceeding and forward the accused to the CGM to whom he is subordinate, and and the CGM to whom the proceedings are submitted may, if thinks fit, examine the party, recall and examine any witness who is already given evidence in the case, and may call for and take any further evidence, and shall pass such sentence, judgment or order in case if it thinks fit and is according to law. So this is all about section 325 and this is all about section 71. If we could summarize it, we could say that if offender could be charged with many more offenses, but unless it is expressly provided, he could not be punished with every kind of offenses. He could punish with only one offenses. But if magistrate and what if magistrate he is guilty for different kind of punishment or a more severe than magistrate is empowered to inflict, if that magistrate is of second class magistrate, he could forward that accused to the CGM and CGM will pass the sentence according to the law. Now we will move on to the section 72. 72 says that punishment of person guilty of one of several offenses and judgment stating that it is doubtful of which. If we could relate it from section 221 of CRPC, we could say that if there is doubt of which offense he has committed, we could charge with any or all of such offenses. But if there is doubt of which sentence he could be awarded, we could see the section 72 of Indian Penal Code, that if the punishment of person guilty of one of several offenses, judgment stating that it is doubtful of which. In all cases in which judgment is given that a person is guilty of one of several offenses and it is doubtful of which offense he is guilty, the offender shall be punished for the offense for which the lowest punishment is provided if the same punishment is not provided for the all. So section 72 defines the if there is doubt, if there is confusion in the mind of court that a person is guilty of one of several offenses but for which he is actually guilty, the offender shall be punished for the offense for which the lowest punishment is provided if the same punishment is not provided for all. So this is all about section 71 and 72, and there is if we could relate from procedure, we could relate it from section 325 as well. So now we will move on to the third part, which is enhanced punishment for subsequent offense, which is section 75. So section 75 lays down the law regarding previously convicted offender, and for the application of this section, 3 conditions are necessary. First condition, what? The first condition is the offense must be one under either chapter 12 or chapter 17. Chapter 12 deals with offense against or relating to coin and government stamps, and chapter 17 deals with the offense against property. And second condition is the previous conviction must have been for offense punishable with imprisonment for not less than 3 years. What does here means? It means that in the first instance, offender has committed any offense which is punishable with 3 year or punishable with imprisonment of 3 year or upward, and when he has subsequently committed the offense, it is also punishable, or it is also the offense which is provided under chapter 12 relating to coin or government stamp, or offense under chapter 17 which is offense against property, and it is also awarded with 3 or more year of imprisonment. In that case, when the person who is previously convicted for that type of offenses which is provided under chapter 12 or 17 of Indian Penal Code, and subsequently committed the same kind of offenses, he will be awarded with a punishment which is imprisonment for life or imprisonment which may extend to 10 years. So he will not be punished with the imprisonment which is provided for that offense. He will be subject to the enhanced punishment. He will not be awarded with that punishment which is provided for that offense particularly, because he is previously convicted, so he will be the subject to enhanced punishment, and he will be punished with imprisonment for life or imprisonment which may extend to 10 years. And attempt or abetment is not provided in this section. This section does not apply to the cases of attempt not specifically made offense under chapter 12 and 17 of the code, and nor the cases of offenses which fall under section 511 of this code. And abetment, it does not also apply to the abetment as well. The previous conviction of an accused for an offense under chapter 12 and 17 cannot be taken into consideration at a subsequent conviction for abetment of an offense under those chapters for purpose of enhancing punishment. So this was all about section 17.